Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinsky, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspar.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show. Our podcast show today is part one of a repurposed webinar that we produced on August 13th of this year. The title is The Supreme Court's Landmark Ruling on Universal Injunctions. In part one, we will be talking about the majority opinion in the Supreme Court case called Trump v. CASA, that's C-A-S-A, the concurring opinion of Justice Kavanaugh, the statement in particular that the Supreme Court will continue to use its emergency docket to act as the ultimate arbiter on the propriety of injunctive relief. And we'll also be discussing in part one the dissenting opinions in Trump v. CASA. In our podcast show 1 week from today, we will continue to talk about other important topics related to the Trump v. CASA opinion, including what I'm referring to as the class action and the complete relief workarounds to the opinion of the Supreme Court invalidating the use of universal or nationwide injunctions. We'll also be talking about the future implications of Trump v. CASA on everyday people and the shaky future of associational standing. That means when a trade association is the plaintiff in a case where it is representing its members in bringing a claim. And then we'll finally wrap it up with a discussion of how much further will the Supreme Court go in expanding the use of the so-called unitary executive theory. The theory that President Trump has been pushing to an extreme in which the executive has powers that other presidents haven't really tried to utilize in the past. I'm very pleased that we have been able to assemble for today's webinar a panel of distinguished legal scholars and seasoned litigators who will analyze the court's majority, concurring, and dissenting opinions and explore the historical and constitutional foundations of the decision and assess its far-reaching impact on industry stakeholders, trade associations, federal agencies, the judiciary, the executive branch, and everyday people. So here are your presenters for today, and they are in alphabetical order. They are all very distinguished lawyers in their own right. So to the right of my photo is Suzette Malveaux. She's the Roger T. Groot Professor of Law at Washington Lee University School of Law. Over the last 20 plus years, she has taught civil procedure, complex litigation, employment discrimination, civil rights, and constitutional law. She has been cited in opposition in the Trump v. CASA opinion and in Trump v. Hawaii regarding the propriety of universal injunctions. Her writing focuses on issues at the intersection of civil procedure and civil rights with a focus on access to justice. Next is Carter Phillips. Carter is one of the most experienced Supreme Court and appellate lawyers in the country. As a partner at Sidley, he has argued 82 cases, that's right, 82, before the Supreme Court, more than any other lawyer in private practice. Prior to joining Sidley, Carter served as an assistant to the Solicitor General, and in that position, he argued nine cases before the Supreme Court on behalf of the government. He thus currently has a total of 91 oral arguments before that court. And then last but certainly not least is Alan Trammell. Alan is a professor of law at Washington Lee University School of Law, where his teaching and scholarship focus on civil procedure, federal courts, and constitutional law. His scholarship has appeared in leading law reviews throughout the country. He's been cited by numerous courts and treatises. His commentary has also appeared in the Washington Post, Slate, and the Wall Street Journal. So with that, Alan Trammell, the floor is yours.
Well, thank you very much, Alan. It's a pleasure to be with you as well as my distinguished co-panelists. As the agenda indicates, I'm going to start with a little bit of background on the procedural posture of the CASA decision, and then I'll move on to talk about the majority opinion. So very briefly on the background. This is a case that fundamentally implicates the Citizenship Clause of the 14th Amendment, the very first sentence of the 14th Amendment, which says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. In 1898, the Supreme Court in the Wong Kim Ark case said that this essentially establishes birthright citizenship. In other words, somebody who is born on American soil acquires American citizenship, even if that person's parents are not necessarily here legally, subject to some very, very few exceptions. On Inauguration Day of this year, President Trump signed Executive Order 14160, protecting the meaning and value of American citizenship. And in essence, it was designed to end birthright citizenship as we know it. This obviously flies in the face of more than 100 years of jurisprudence, and so quite predictably, a number of cases were filed almost immediately. One of those cases, the CASA case, which lends its name to the Supreme Court decision, was filed by an immigrant rights organization representing itself as an organization as well as a number of individuals. So that was the case that led to probably the most sweeping of these universal injunctions, enjoining the president from implementing this executive order anywhere at all in the United States against anyone. There were also some cases that were brought by states, including Washington State and New Jersey, and they were saying that they as states were harmed by this executive order in various ways. Now, the Supreme Court consolidated those three cases, CASA, Washington State, and New Jersey. And what's interesting is that this was put onto the emergency docket. The Solicitor General asked for a very unique partial stay of the preliminary injunctions that had been issued, essentially saying, Supreme Court, what we want you to do is to narrow the scope of these preliminary injunctions to only the actual individuals who are parties to these particular lawsuits. In other words, non-parties should not get the benefit of the preliminary injunction. And that was the question that the Supreme Court took up. There was an expedited briefing schedule, oral argument in May, and then the decision was handed down at the end of June. So let me turn to the majority opinion. I want to touch briefly on just three major points. The first is what universal injunctions are. I want to expand a little bit on what Alan was saying before and what makes them so controversial. Second, I want to talk about the methodology that the majority adopted in analyzing this question about whether universal injunctions are proper. And then finally, I want to touch on what was left unsaid, what remains on the table, if you will, in terms of areas for debate and things that courts are going to have to cash out. So in terms of what a universal injunction is, as Alan said, it's not the breadth of the injunction, the geographic sweep of it, so much as the people who directly benefit from it. There was a bit of a red herring when this debate started about 10 years ago during the first Trump administration. People would often characterize these as nationwide injunctions. But as I say, that's something of a red herring. Equity was always able to intervene to provide so-called complete relief. So to take a somewhat silly example, imagine that I start a chain of coffee shops and I adopt a logo of concentric green and white circles with a jaunty mermaid. Starbucks sues me for infringing their trademark. Well, they're entitled to an injunction that is going to apply everywhere that I might be interfering with their trademark. And obviously, we know that Starbucks is ubiquitous, so that would apply nationwide. But that's not really problematic because it's an injunction against me, a party, benefiting Starbucks as the plaintiff. What makes universal injunctions so controversial, as Justice Barrett points out for the majority, is the who question, not the where question. It is when courts directly and intentionally benefit people who are not parties to the lawsuit. So, for example, people who might be affected by this current executive order, people who claim that it runs contrary to the 14th Amendment, but who are not actually parties to the lawsuit. Now, this was something that courts started talking about early on in the first Trump administration. And Justice Thomas suggested in a concurrence in Trump versus Hawaii that universal injunctions are unconstitutional. They run afoul of Article 3, the way that the jurisdiction is conferred on federal courts. And other scholars had suggested that perhaps they're inconsistent with the case or controversy requirement of Article 3. There are all sorts of practical problems that arose through the issuance of universal injunctions, including forum shopping, and quite predictably that when you had a Democratic president, you would have oftentimes Solicitor General and Attorneys General from red states who would go to favorable courts in red states trying to enjoin Obama-era policies. When the shoe was on the other foot and President Trump was in office, it was overwhelmingly blue state Attorneys General who would go to courts in favorable states and circuits to try to enjoin those policies. Those are practical considerations that courts and scholars have talked about, but they largely are not about the fundamental question of whether these are constitutional. All right, so the second point, what is it that the court did methodologically here? I think there's an important first step, which is that the court does not root its rejection of universal injunctions in Article 3 of the Constitution itself. And we'll talk about why that matters a little bit later on in the webinar, including the fact that this preserves the possibility that, for example, the Administrative Procedure Act could allow for what is effectively universal relief that encompasses everybody who is similarly situated. All right, so instead, what the Supreme Court does is to trace this back to the Judiciary Act of 1789, the jurisdiction that was conferred on federal courts more or less at the founding. But that methodology is a fairly recent innovation. It's what some scholars have called equitable originalism. In other words, this idea that you need to find some sort of historical analog to justify the particular remedy that a plaintiff is seeking. Now, that methodology, this historical originalism, is really tracing back only about a generation to the Grupo Mexicano decision from 1999, a series of other opinions by the Supreme Court that more or less have taken the same approach. Now, if you're looking for a historical analog, there are a couple of possibilities. Probably the best one is what was known as a Bill of Peace back in England. So this was a centuries-old device that adjudicated the rights of a group without formally joining all of those interested parties to the lawsuit. So it seemed, at least based on the Supreme Court majority's methodology, this was a pretty good analog for adjudicating the rights of non-parties in a conclusive fashion. Justice Barrett, though, tracking a number of scholars, says that's not really the case. Bills of Peace, according to her, applied to a small, cohesive, readily identifiable group. And more or less, she says, the modern analog of a Bill of Peace is not a universal injunction, it's a class action. She also takes up taxpayer lawsuits and says, well, even though that provided what we might think of as universal relief, those taxpayer lawsuits really only trace back to about the middle of the 19th century. So it's not a historical analog rooted in 1789. So it's unsurprising, given this particular framing that, and the originalist bent of the current Supreme Court, that these were more or less the terms of debate, figuring out what a Bill of Peace was, whether there were these historical analogs, and very critically, trying to identify when the first modern universal injunctions were issued. Some people like Professor Sam Bray saying, well, they trace back only to the 1960s. Professor Mila Sahoni at Stanford would say, well, they trace back earlier to the 20th century, perhaps even to the 19th century. I want to put a pin in that for a moment and note that Justice Jackson in dissent frames the entire discussion quite differently, saying this historical originalism approach is not consistent with the way that jurisdiction is conferred on federal courts by Article 3 itself or even by the Judiciary Act. Equity was always supposed to provide a check, if you will, against lawless government action. So that's one thing to note. It's probably more of an academic debate at this point, whether equitable originalism is even correct as a methodology. But I want to end by noting that the Supreme Court leaves on the table this idea that courts of equity, or federal courts when they are applying equitable remedies, are still allowed to accord complete relief to the plaintiffs. That might be easy when you're dealing with an individual. You provide relief to that particular person. It's harder when we're talking about entities like states, and the Supreme Court more or less punts on that and says, well, we leave it to the district court in the first instance to figure out whether states can, in fact, demand universal relief because of the cross-border flow of individuals and their children and the practical ramifications. So that's going to tee up something that some of my co-panelists are going to talk about, which is the future of organizational and associational standing, whether organizations, NGOs, or whether governmental entities are going to have an easier time getting into court, whether they can more or less try to replicate the work that individuals were doing through universal injunctions. I've probably spoken for a bit too long, but I'm very excited to hear what my co-panelists have to say. Thank you.
Yeah. Well, thank you, Alan. And let's go to Carter Phillips now, who's going to talk about the concurring opinions in the case and talk a bit about the emergency docket that the Supreme Court used here to come down with this result.
Thanks, Alan. Let me start, though, by asking the other Alan before we move on to it. Do you have thoughts about the Solicitor General's strategy in just raising the injunction issue and not raising what I think the average person would think is maybe the more fundamental question that requires a uniform answer, which is whether or not birthright citizenship has limitations on it, or that the 14, or what the jurisdictional authority is? I mean, the case seems odd in that respect to me because, I think the news in general, said the court's going to decide birthright citizenship. I mean, I knew that wasn't true because I looked behind it, but that was really the headline. Then you come out with this ruling, which again, because this webinar tells you it's obviously an important issue that was decided, but it still seems strange to me. Alan, you've looked at it more carefully than I have. You have any thoughts about
it? It is extremely strange. One of the ideas that I'm working on right now that kind of brief in my Slate commentary is that the Trump administration can win by losing. A whole lot of what they're trying to do is not actually to win at the end of the day in court. They're trying a number of delay tactics, and they're trying to sow confusion and chaos. And the more time that an executive order exists before a court definitively strikes it down, the more chaos they can sow. One of the things that I've heard in terms of speculation is that Chief Justice Roberts and perhaps the majority were attempting something of a Solomonic solution, recognizing that the bona fides of birthright citizenship are pretty rock solid. And so this was a way of giving the Trump administration something that it had asked for the first time around, which is a ruling that universal injunctions are improper, whether on a constitutional or a statutory basis. And then maybe that gives the Supreme Court a little bit of cover to reaffirm Wong Kim Ark. But I'm bad at reading tea leaves, so that is the best that I can come up with. But again, I think that it's consistent with this delay tactic that we see across a whole other spectrum of executive actions.
Yeah, I'd like to just add something and ask you the question, Carter, and that is, and it ties in with the topic that you're going to talk about. And it seemed to me that it was pretty clever lawyering on the part of the Justice Department, teeing up the issue in the way that they did so that it was their belief the court would not reach the ultimate question of birthright citizenship. And what I'm wondering is whether the court could have or should have rejected that strategy and had said, no, we want to look at the whole ball of wax. You file a cert petition where we want to deal with everything.
Yeah, so that does feed directly into Justice Kavanaugh's concurring opinion, because in funny ways, the way he analyzes this problem, I mean, this is the first substantive defense of the use of the emergency docket as a method of sort of fundamental decision making, both in terms of why they do it and that it's not only appropriate but in some ways almost necessary for the court to intervene the way it has in the last, say, 10 to 15 years. Just for a little historical context, because I was in the Solicitor General's office during the transition between the Carter and the Reagan administration, and not surprisingly, there was a whole lot of hubbub about actions taken by the Reagan administration and litigation that went on, and a lot of complaining about not moving fast enough to stop the flow of the new administration's efforts or judicial interference, et cetera. And at least in those days, the Solicitor General's response was, look, there's an ordinary process. The court prefers an ordinary process, and the cases will make their way up to the Supreme Court in due course. So we didn't typically, we didn't think about skipping the courts of appeals, getting judgment before, getting certiorari before judgment. The Solicitor General didn't generally authorize emergency relief unless it was really a life and death kind of situation. So it's kind of interesting. I mean, part of the reason why the emergency docket has taken on a much greater life of its own is because the executive branch has decided to push that button much more aggressively. Now, the court way back when could have stopped it by saying, look, we're not getting into this business. We have an orderly process. The emergency docket obviously has been around for a long time. It's available for incredible situations, death penalty being the most obvious one. But, situations where the court adjoins bombing of Cambodia, that kind of thing, there are obviously situations that are just almost mind-numbingly important, and the court would intervene in those. But for the vast majority of cases, the court sort of stayed away. And now we're in a situation where it seems like every week we get a new emergency docket order coming out of the court. And part of that's because the president obviously is issuing executive orders right and left. And that's creating a lot of buzz. So when the controversy originally arose, probably 5-6 years ago, and the press, probably longer than that, maybe 8 years ago, and the press started to make a genuine criticism, or began to criticize and describe this as the shadow docket, right, rather than the emergency docket, to make it appear more nefarious, and criticizing the court for deciding what seemed to be pretty important issues on the basis of a process that was significantly truncated. Right? You didn't have full briefing and oral argument. You simply took the papers that came up on the application for a stay or an application for an injunction and acted on those papers in an extremely fast fashion. So there was a fair amount of blowback on that. And then, interestingly, the court obviously reacted to that to some extent, because in the next wave of those efforts, the court started to do what it did in CASA, which is get an emergency application, treat it as a petition for certiorari, and then hold full briefing and oral argument, but on a truncated basis. From the court's perspective, that probably seems like a perfectly adequate way of going about it, because the court's used to getting full briefs and oral argument, and usually have to act on them pretty quickly, because the court's docket has shrunk so significantly that you almost as quickly as you can get cases briefed and ready, they're ready to be argued within literally a week after the reply brief is filed. So truncating everything doesn't really affect how the court looks at a particular problem, other than it may have to act more rapidly afterwards. But it does significantly affect, obviously, how the litigators go about dealing with the issue, because they have to file their briefs in an amazingly short order and without the benefit, obviously, of the kind of percolation among the lower courts that traditionally serves as the basis for the court to review it. So the court, I thought, made some adjustments, not to say that they grant cert and treat all of these cases that way. There's certainly a fair number that still get decided on a very summary basis and raise a whole set of questions about sort of what precedential import those have. But several years ago, Justice Alito, defended the use of the emergency docket by challenging the attack on it as basically a partisan attack and a media-driven attack. By contrast, Justice Kavanaugh's effort here was to actually defend it on its own terms, which is to say, we have certain issues that are so incredibly important that you need an answer. You need a national answer. It's not appropriate to have these things decided on a regional basis. And therefore, the court has to step in, and we have to be the decider. Now, that's an interesting proposition. It's not one that's based on history, because historically the practice was not to ask the Supreme Court to be the decider, and so regional differences existed, and the process went on. And as far as I can tell, the world didn't come to an end up to the point when President Trump was elected the first time around. So it's not obvious to me that he's right about that particular need. And then the second part of this is and the anomaly of it in some ways is, he sits there and says, this is a really important issue, whether or not you can get a universal injunction. It needs an answer now in order to guarantee that we can decide in the interim period when litigation is ongoing, sort of what rule applies and what rule doesn't apply. But it's at least anomalous that the court doesn't actually decide the birthright issue, because that is the most important issue. That's the question that needs to be resolved. The court punts that one down to whenever it comes back around in due course, which seems to me at least completely at odds with the premise of Kavanaugh's analysis of this. It'll be interesting to see if there are future efforts by the court to debate the emergency docket. I'm sure that, I know Justice Kagan has made comments about it in the Ninth Circuit's Judicial Conference, but I think there'll be a continuing battle over the emergency docket, et cetera. But, basically, in some ways, Kavanaugh's defense is in some ways a defense to the court's overall docket, right? So we used to decide 160 cases. Now we decide 55 cases, but we decide a whole bunch of these other emergency docket things. So you ought to give us some, cut us some slack in terms of whether or not we're getting our job done or not. Of course, the answer to that was you could simply have said no and allowed the litigation to go forward and go back and decide another 100 cases on the merits. Anyway, it's an interesting opinion. It doesn't really bear directly on the injunctive relief issue so much as it does on the sort of fundamental debate about the use of the emergency docket.
Yeah, Carter, I really had two questions. One is I'm wondering if the Supreme Court could have taken up the constitutional law issue, right, the constitutionality of the executive order, was that within, I know that wasn't what the government was asking for, but did the court have the prerogative to do that? And there seemed to be an oral argument, some kind of discussion about whether to what extent the court could veer from that question about remedy. And then the other thing I'm wondering about is just the competence of the court. And so one of the things that concerns me, and you mentioned the fact that the court, I think at this point, takes less than 1%. The cert petitions, grants less than 1% of the cert petitions that are filed. It's a very small docket, and then is deluged by the administration's executive orders. There may be, I think we're maybe over 170 at this point. In terms of the competence of the court, if you think that the court is well positioned to take on this uptick in emergency docket cases, because Kavanaugh is saying in the opinion, we promise not to hide in the tall grass, we can do this. What is your take on that? Do you think it is designed to do that and handle that well?
So the interesting thing, I'll answer both questions in turn and in the order you asked them. Obviously the SG did not present the constitutional issue, so you could argue that since it's not within the question presented, they couldn't decide it. On the other hand, it seems at least mildly strange to be devising a remedy without being confident that there is in fact a basis in liability that requires remediation in the first place. You can obviously assume it arguendo for purposes of getting to the second issue. And the truth is, the court's been, or at least a segment of the court has been clamoring for a case that allows them to get at the remedial issue all along. And so the SG, I think strategically and for the purposes of the administration pushed it and to get at it that way. But I think it would have been hard for the court to leap and take the constitutional issue. I mean, in an odd way, it probably had more authority to do that because it was in the emergency docket. You were already going to treat the emergency docket as in a way different than it was intended. We're going to treat it as a certiorari petition. Doesn't mean you could, in theory, treat it as a certiorari petition and say the issue of the fundamental issue is itself important and maybe the more important question. But I think you would have had to at least say that at the point in time when you granted the decision, when you issued the decision that we're going to stay it and then have full briefing on the issue on an expedited basis. As far as the competence of the court to do this, I mean, I always thought that when the court was deciding 160 cases, it was really stretched to the limits of what you could realistically expect out of a 9-member body, because it's not easy to get agreement of 5 justices on any given opinion. May be even harder these days than it was at least when I was clerking 100 years ago. So the idea that the court's going to only decide 50 some cases on the full plenary merits process and then another 100 in some cases on an expedited basis is seems to me sort of crazy because the emergency cases take a lot out of you. Fortunately, when I was clerking, I think we had one really difficult case in the emergency docket, which was a death penalty case. But the idea that every week you're going to end up with potentially 1 or 2 really hard issues, and that are either brought to you by the federal government or by a state government. And you can keep docking all the issues where the private parties bring them because that's the court has continued that practice. Very, very hard for private litigants to get a stay other than in a death penalty case. But if you take seriously the idea that you have respect for the states, it's on a par with the federal government, and the states have standing to challenge virtually everything these days. Which again, that was a rule the court decided to go down that path when it decided the Massachusetts environmental case. They have sort of brought this on themselves, and whether they're going to be able to how they're going to be able to deal with it, I think is a fair question. I don't have great confidence that they're going to get any better at it. And Kavanaugh says, just because we decide it this way now doesn't mean we'll decide it this way 4 years from now. But the reality is that I don't think anybody seriously thinks that very many cases are going to flip during that 4-year period. And so, what you get now is going to be probably what you're going to get, and you might not want, at least as an institution, you probably would prefer a better decision-making process than the one they're working on currently, especially if the pipeline gets really overflowing, which I have every reason in the world to believe it will be.
Yeah. Yeah,
okay, Suzette, why don't we get into the dissenting opinion?
Yeah, thank you for inviting me to participate. I'm thrilled to be here. Let me just jump into the dissents. There are two. There's a primary one by Justice Sotomayor, which was signed on by Kagan and Jackson. And her dissent was actually longer than any of the other opinions. So it's very meaty. And I think what's really interesting about this dissent is that she actually does get into the substantive claim, the merits of whether or not the Birthright Citizenship executive order is illegal and unconstitutional. So that is front and center to the dissent. And she makes it very clear that the executive order is illegal, that every court that has actually looked at this has said it's patently unconstitutional. And I think she makes the persuasive point that no right is safe if this one isn't, right? So that she sort of sends out some warnings about what other administrations in the future might do, whether it's a Second Amendment and the government decides that law-abiding citizens can't have firearms or people can't pray as they would like to, and sort of obvious Second and First Amendment violations of the Constitution, and that's par for the course, right? That none of those rights are safe if this one isn't. And she makes it really clear that she refuses to be complicit in what she characterizes as a grave attack on our system of law. And what she does in her dissent is she connects the order's patent unlawfulness with the need for universal injunctions, right? And she demonstrates how important and how serious a mistake the majority's opinion is, and how important equity is, and in terms of supporting universal injunctions. And so I thought what was interesting, she sort of sums it up and says, outside of the cumbersome class action litigation, which we'll talk about later, courts can enjoin plainly unlawful policies unless doing so is necessary to afford parties complete relief. And she walks through all the different sources as to why this executive order is illegal, right? So she looks at the text of the Constitution, she looks at legal history, she looks at equity, jurisprudence, federal law, longstanding executive branch practice for over 100 years. And all of that is pretty much it's all consistent in terms of saying that birthright citizenship is a fundamental right under the Constitution, under the 14th Amendment. Really, the only exception to that was the infamous Dred Scott decision in 1857, which ultimately led to the 14th Amendment's Citizenship Clause. And as Alan mentioned, the Supreme Court itself has affirmed the right to birthright citizenship in the Wong Kim Ark case that was decided in 1898. So that has been repeatedly reaffirmed. All three branches of the government have unflinchingly adhered to this particular standard. We know that all three district courts granted injunctive relief in the birthright citizenship case below. We know all three circuit courts of appeals then affirmed those nationwide injunctions. And so what Sotomayor does is she goes through why it is the government failed to meet its standard for a stay of the preliminary injunction. And there are basically two criteria. One is the idea that the government is going to suffer irreparable harm if there isn't a partial stay. And she balks at that and says, how is that possible to suffer irreparable harm to continue the status quo that has existed over 100 years, right? So this doesn't make sense where the government actually doesn't have a right to enforce the executive order against anyone, much less just the parties below. And so she concludes here, this court endorses the radical proposition that the president is harmed irreparably whenever he can't do something he wants to do, even when what he wants to do is to break the law, right? So that's the first thing, the notion of irreparable harm. The second thing she pushes back on is this idea that the government will likely succeed on the merits when it comes to the scope of remedy. And again, it's a very comprehensive look at the history and tradition of the scope of remedial relief. She looks at centuries of equitable principle and practice to make her point, and she leans into the idea that equity is really a flexible doctrine. It's supposed to be adaptable. It provides benefits parties and non-parties alike. And as Alan mentioned, Justice Sotomayor, she looks at bills of peace and taxpayer suits as examples of that. And so really it's sort of the majority and the dissent having a different way of thinking about the very same history. And the Justice Sotomayor, the dissent here, relies on Professor Mila Sahoni's good work here, showing that there are deep roots in equities history and the Supreme Court in terms of the scope of relief. And so that what this really is in some ways selective originalism, right? Where you have the courts, the different sides are sort of cherry picking cases to support their arguments. I will say that Sotomayor's dissent does not get into too much about the prudential concerns related to nationwide injunctions. She does mention some of the drawbacks, things like percolation, forum shopping, asymmetrical enforcement, but then she says that they don't really apply here, right, to this case. So she concedes this, but doesn't give it a lot of space, which may have been interesting, right, may have been worth doing. But the pushback here is that the majority has decided to strip the federal courts of power that they have to issue nationwide injunctions, even when we have a flagrant unlawful government action at play. Justice Sotomayor also does an interesting test of the balancing test between the public interest or the equities between the government and the newborns that would be harmed by this executive policy, basically talking about clearly the newborns lose this calculus in terms of losing a fundamental constitutional right. She says that this would in fact create a shadow population. She's imagining things, deportation, total chaos, people who are stateless. And so the kinds of reparable harms, clearly in the balance, the newborns are the loser. Her dissent does talk a bit about the courts as a check on an abuse of executive power, and that's basically taken away. Basically, there's no protection unless you happen to be a party in a lawsuit. And what was fascinating and really powerful is she said even the Supreme Court itself, she seemed to say that the Supreme Court itself doesn't have the power to issue universal injunctions beyond the parties, and that it's naive to believe that the government will treat the Supreme Court's own opinions as de facto universal injunctions. And so I thought I think that's really wild. In terms of the rule of law, she also questioned whether or not the substantive question of the constitutionality of the executive order would in fact ever come to the Supreme Court, that's not a guarantee. And of course, that's because the government, as the loser below, gets to decide what to appeal. So we'll see if in fact that substantive rule of law question comes up. She did at the end give somewhat of I'm going to say a shout out to Rule 23, class action device, but she said, this is not a perfect substitute by any means. And she laid out a number of the concerns that people have about class action certification and some of the difficulties that we can talk about later. But she did ultimately outright suggest that plaintiffs bring class actions in short order in order to get preliminary injunctive relief, at least for a putative class. But ultimately, she concludes by condemning the court as a branch of government for failing to fight for the rule of law, and says that every branch of government needs to have the courage to do that if rule of law is going to survive. And so she concludes that the court has abdicated its responsibility in that effort, and that's something she does not want to be complicit in. So that's the primary dissent. There is a separate dissent by Justice Jackson, and she really takes a different take. This is something that Alan had mentioned earlier. She signs on completely to the other dissent, but she says here that the idea that the court is permitting the executive branch to violate the Constitution as it pertains to those who don't bring lawsuits is an existential threat to the rule of law. So that is her number one point, that she leans into the idea that this is a nation of laws and not men, that everyone is constrained by the law and there are no exceptions, and that the court has to have the power to order everyone, including the executive, to follow the law full stop, right, across the board. And that the consequence of not having that is basically you end up creating what's called a zone of lawlessness. And that is a group of people who are subject to the whims of the president, who actually don't have the same constitutional rights that others do by virtue of their being marginalized and not being empowered. So that's a particularly important theme that she leans into. So she talks about separation of powers. She does more along the lines of checks and balances. In particular, she's looking at the checks and balances between the judiciary and the executive branch. And she calls the majority opinion profoundly dangerous, that it gives the executive branch unchecked arbitrary power. And I thought what was very telling is the way she dissented. She said, with deep disillusionment, I dissent. And so that just sort of stuck with me. That is a strong, really powerful critique of where we are and what she thinks about the court's ruling. So the basic idea here, she talks about the role of the federal courts is really two things. One is to say what the law is, and the second is to enforce it. And she sort of goes down this path of, quoting Marbury versus Madison, Hamilton, and all of the figures, right? All the venerable figures from the past, and comes to the conclusion that the court here, the majority, has a very limited view of the power of the courts. And really what the majority has told us is that the courts, all they do is afford a plaintiff complete relief in cases brought before them. That's it. And she calls this a conceptual fallacy. And she says that conceptual fallacy comes from the fact that we are looking at the 1700s, the High Court of Chancery in England, and we are not transitioning to the U.S. constitutional system, where the American people have clearly decided that the king does not rule, and that we have a constitution, and that rule of law is what trumps everything. And so the idea here is that the majority opinion is really asking us to think small about the role of the federal courts. And it may be true here that in the Birthright citizenship case, you may end up getting the same outcome. We may end up getting nationwide universal injunctions through the complete relief doctrine, but she says that that's not the point, right? The point, there's something far more serious about this case. And she says she calls this decision a seismic shock to the foundational norm. And that norm is that everyone is bound by the law. And that by having these carve-outs for two different zones, you're basically creating two tiers of justice. On the one side, you have people who are able to litigate cases, wealthy, well-connected, and so forth. On the other side, you have those who are, and she says, the poor, uneducated, unpopular, those who can't lawyer up, and that there is a fundamental attitude problem on the part of the majority, and that it sees constitutional rights, fundamental rights, as entitlements, things that you have to earn, things that you have to sue for to protect, rather than that being your default, and that's the default for everybody. And that where we are today is that the executive can do whatever it wants to whomever it wants, unless you sue to protect yourself. And that we have fundamentally this sort of burden shifting is sort of perverse. And so she ends saying that she is not going to be complicit in creating a culture against the lower courts that is to our collective demise. So I'll leave it there.
Yeah, thank you, Suzette. Well, I want to thank our speakers today, Suzette Malveaux, Alan Trammell, and Carter Phillips. And I want to tell you all to stay tuned for next week's podcast show, which will be part 2 of our repurposed webinar. And just to remind you, next week we'll be talking about the class action and complete relief workarounds, future implications of Trump v. CASA on everyday people, the shaky future of associational standing, and how much further will the Supreme Court go in expanding the use of the unitary executive theory. So to make sure you don't miss any of our future episodes, subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast@ballardspar.com. Thank you for listening and have a good day.